of Anand Law College. I am glad to be present here to welcome all of you on today's international webinar on mandatory mediation programs, jointly organized by Anand Law College and Anand College of Legal Study, managed by Sri Ram Krishna Seva Mandal. I would like to welcome our esteemed guest speaker, Dr. Nahya Acharya ma'am. A very warm welcome on behalf of our both the institution, ma'am. Once again, welcome to ma'am. Now, I would like to welcome on behalf. I would like to introduce our today's expert and guest speaker, Dr. Nahya Acharya, is an assistant professor at the Schoolis School of Law, Dalhousie University in Halifax, Nova Scotia, Canada. She has completed her LLB from the University of Alberta in Edmonton, Canada, and her master and doctoral studies at the Schoolis School of Law, where she now teaches. Her research and teaching interests include legal ethics, civil procedure, legal education, and alternative dispute resolution. She has published several journals of interest of legal practitioners and academic as well as those in higher education, including Advocates Quarterly, Canadian Journals of Law and Jurisprudence, Twins Law Journals, Canadian Legal Education's Annual Review, and Critical Education. Now I once again very welcome to our both the institution, Madam Nahya, Madam. Thank you very much.
Thank you so much. Thank you for the introduction. Am I good to start?
Thank
okay.
You, thank you.
Great. Okay, perfect. Well, it's so nice to see all the people logging in. I'm getting little messages that there's so many people still logging in. So that's so nice that there's so much interest in ADR where you are. So thank you again for the introduction and for the invitation. It's a huge pleasure to be with you, despite being so far away. But I was so excited to speak to Indian students and to get to know your institutions as well. So thank you so much. I don't know how you guys found me, but I'm glad that you did. I'm glad that I got a chance to come talk to you. So just as your principal mentioned, I am an assistant professor at the SCHULICH School of Law, which is in a small kind of coastal city in Eastern Canada. So like you mentioned, I teach civil procedure, which you guys all probably take at some point in your law school career, ethics. But then I've also developed this really central interest now in alternative dispute resolution, which I know you are all interested in as well. So it's so nice to be able to speak with you about these things and just some of it's a relatively recent interest for me. So I'm going to share some of my fairly recent thinking on it, and then hopefully we can have a lively discussion thereafter. So my basic plan is to focus our conversation around the concept of mandatory mediation. So where courts or legislators say, in order to pursue your legal claim, you have to mediate first. You have to try mediation first. So I want us to think about, like, is that actually a good idea, and why or why not? So in the course of explaining why I think it's a bit problematic, I'll be able to tell you a little bit more about what our mediation systems look like in Canada. And yeah, so hopefully we'll have a nice discussion after that. So here's my basic concern. So first of all, like most of you, I find mediation to be really valuable and a really interesting form of dispute resolution. For lots of reasons, right? Among those are, and you can come up with these reasons too, but for me, it has a lot of procedural flexibility compared to adjudication. It can give rise to really flexible outcomes compared to the judicial system. And if it's done well, then it can enable parties to communicate with one another, come to understand the issue from each other's perspective, come to at least ideally, a cooperative outcome. And importantly, it allows participants to actually determine their own outcome rather than in adjudication where the judge tells you what the outcome is going to be, and that's authoritative, right? So it has a lot of pretty deep values as a dispute resolution system. So I was generally pretty happy to see that it is being increasingly used and endorsed in the civil justice system in Canada. So on the one hand, it was very nice to see mediation becoming so widely embraced in the legal system. But at the same time, I felt kind of uneasy about it, because here in Canada, and I suspect that there's similar dialogue or narrative in India, but over here, mediation is largely related to efficiency. Like, that is the key value that people always talk about for, if you ask someone, why is mediation a good thing? The primary thing they'll say is, well, it's fast. Like, it's a fast way of getting rid of disputes, right? So you can see on the slide, I have like a number of quotes that are from different people in the Canadian system. Like, we have a Chief Justice here saying all these different quotes that relate to just efficiency, time, expense, efficiency. So that's what you primarily hear, right? You hear people saying mediation is great because it's faster, it's cheaper, it's easier than adjudication. So we have this kind of like dominant efficiency narrative happening. And that's understandable to a degree, because access to justice is a real problem if the court systems are backed up and are generally inefficient. So I understand that efficiency is an important value. And this, I think, you guys in India maybe know better than anyone else what it means to have a backlogged judicial system, right? So I understand that push for efficiency. But I think that it's problematic for efficiency to be the only dominant narrative in terms of whether and how mediation should be incorporated within the court systems. So let me just break for a second and tell you what we have in Canada. So I think you probably know, we have a federalist country. So every province, there's obviously a central government, and then each province has control of certain things. And here, each province is in control of its own judicial system. So in some places in Canada, we have court-connected mediation programs, but the parties get to choose if they want to try mediation or not, right? So we have a program set up, and if you want to try it, you can go and try mediation. But we have a couple of jurisdictions in Canada where the courts or the legislators have said, no, you actually have to mediate before you can have your case actually litigated. So at some point in the process, you and the other side are going to have to try mediation. So it doesn't demand that you have to settle, but it demands that you try the mediation process. So my concern is primarily with that, because I think adopting a mandatory process largely on the basis that it's fast is a bit unsettling. Because obviously fast is valuable, but fast doesn't always equate with good or just, right? So if the dominant narrative is fast, then we may be in a problematic situation. So what I want to explore with you today is whether mandatory mediation is actually justifiable beyond just the fact that it's fast. Is it actually justifiable from the perspective of achieving a more, let's say, like a substantive form of justice, right? Not just justifiable on the basis of efficiency, but justifiable on the basis of something more solid than just efficiency, something more substantive. So, and I think this is relevant in the Indian context as well, because I don't know much about how the court systems work in India, but I did kind of a quick review, and you guys can correct me, but if I read it correctly, it seems like there's a section of the Civil Procedure Code where the courts can direct parties, right, to pursue some sort of settlement procedure. And it also recommends settlement procedures in some instances, like I think in family disputes, mediation is recommended. And I'm also really interested to learn more about the Lok Adalat system, which I don't know too much about, but which I think has some good lessons for Canada. But in any event, I think the conversation around whether mandatory mediation is a good idea is relevant in India as well. So my approach is from like the angle of saying, is mandatory mediation a legitimate addition into the civil justice process. And the approach is premised on an idea which, I think has to be defended, but I think you'll probably find is also an uncontroversial premise, that a legitimate civil justice system has to demonstrably recognize and uphold equally everyone's human dignity. I think that is kind of like the crucial core feature of a valid legal system that deserves the authority that it asserts, right? Legal systems are authoritative. They can force us to do things. That has to be justified in a free, democratic society. So I think that's justified when the legal system can also demonstrate that it respects all of our dignity equally. So that's the basic premise. It's like, that's what constitutes a legitimate legal system. So then my question is, well, how does mandatory mediation fare in that respect? Does it help us respect everybody's dignity, or can it possibly detract from maintaining and respecting everybody's dignity? Okay, so you guys with me so far? Okay, so I'm going to try to approach that from 3 different angles. Let me just change the slide there. Okay, so I kind of adopt 3 different pieces. So the first is the theoretical piece. So this is the idea that centers on the fact that mandatory mediation can be interpreted as an inappropriate hurdle to accessing rule of law, and that can be an affront to litigants. So in other words, forcing somebody to try mediation can be an inappropriate barrier for them to access the actual adjudicative system. So I'll talk about why I think that could be a problem. So that's the theoretical part. And then the practical part is that court-connected mediation seems to be less about enabling an actual dialogue between 2 parties where the parties actually come to a truly self-determined consensual outcome, because that's what I think ideal mediation is. I think court-connected mediations are usually more about getting at a settlement. And that's related to what I talked about before, which is the overemphasis on efficiency. Because if your primary goal is efficiency from a mediation program, right, then of course, what you want out of a mediation program is to get a lot of settlements, so those cases go away. So settlement is like the primary objective. Now, my concern is that getting a settlement as the primary objective of mediation can result in various types of coercion or pressure on one or both of the parties. And that can be very compromising to the dignity and autonomy of one or both of the parties. So we'll talk about that a little bit more. And then the third angle, which is very related to the first 2, is kind of like what I am just trying to label the social justice angle. So that involves the problem that critical race theorists have pointed out and feminist perspectives have showed us, that mediation or informal dispute resolution, where there's no oversight, there's no public scrutiny, in those contexts, it seems that people who are already marginalized in a society, so here in Canada that often includes Black people, Indigenous people, women, and then generally people of color as well. So all of those people are already marginalized. They, it seems, tend to do worse in informal mediation types of contexts. So all of these things taken together seem to constitute to me at least a potential for being an affront to human dignity. And that suggests that mandating mediation may not be a legitimate civil justice reform, or it may not be a legitimate part of a civil justice process because of its potential impact on human dignity. So that's one piece of the argument. But the other thing is that simultaneously, as I began with, I do think mediation has a significant role to play within civil justice. So I'll end with what I think is a viable way forward, which is how do we make good mediation programs available to people through the court systems, but not having to actually mandate them so that people have to go through the civil justice process. So I'll end with just some kind of general thoughts on how we might move forward. So let's dig into the three angles. So did you guys want me to stop for questions in between, or should we just do questions at the end? Sounds like we can do them at the end.
Yes, ma'am, I think we should just do the question answer session at the end.
Okay, sounds good. I was just asking because I think I saw someone's hand go up or something, but okay. So let's get into the three angles. So the first is the rule of law angle. So this is what I call the theoretical angle. Okay, so my first concern is that the discourse around mandatory mediation sometimes, and you guys tell me what is like in India, but sometimes over here, when we're talking to mediation people, like proponents of mediation, oftentimes what you hear is people kind of like essentializing adjudication as, or let me put it this way, describing adjudication as primarily just an annoying, cumbersome, expensive, and sometimes even hurtful because of its adversarial nature process, right? Like they see adjudication as this like kind of bad thing, which it is. But I think that those things are better defined as some of its ancillary qualities. And this is important because when we define adjudication primarily by all of the shortcomings that we see with it, then the risk is that we forget what we're losing when we deny a right to have your case tried in court, in the adjudicative system. Because, we adopt the narrative like, oh, we're just denying you the right to this annoying, cumbersome system, so who really cares, right? But I think that's a very risky way of viewing adjudication. So, I think the first important thing is to approach the discussion from a place of recognizing that adjudication is imperfect, but it's also indispensable in the sense that it's an indispensable mechanism for maintaining the rule of law. So this is how this relates to the rule of law concern here. See, because without an adjudicative system, one second, someone took control of the, okay, there you go. Okay, so without an adjudicative system that's purpose is to administer the laws as they exist, rule of law doesn't exist, right? Like, we can have a bunch of laws written by the legislators who are democratically elected and all that, but if we don't have a court system whose primary purpose it is to administer those laws and only those laws, we don't have rule of law. But what's the point of having laws if we don't have an adjudicative system that's going to administer them if there's a problem, right? So this is dangerous because the rule of law is important. And it constitutes, I think, so that is rule of law, constitutes a commitment that we are all non-arbitrarily treated under the law. That's like the basic premise of rule of law, right? Like, we're all subject to the laws. No one's above the law. We all have equal access to the benefits and the obligations of law. Now, that's an ideal, and I know in any society that doesn't always manifest, but that's the ideal, right? That we're all equal under the law. So a rule of law is basically like a promise that when the legal system exercises its authority, it will do so fairly, it will do so predictably, because we know what the laws are, so we know what general norms are going to govern our interactions with each other, and that allows us to then live free, autonomous lives, and we can then make decisions on the basis of what those laws are, and we can say, okay, I'm going to do this because it's consistent with the law, or I'm going to do this knowing that it's inconsistent with the law, and I'm going to accept the legal consequences as a result, right? And we can make autonomous decisions because we know what the laws are, and we know that we have a system that is designed to enforce and administer those laws. And adjudication is essential to that, right? Without adjudication, we don't have that. So that's a huge problem. So that's what we have to recognize that adjudication is when we approach this conversation or question about, well, okay, how do we then how do we then make adjudication and mediation relate to each other? We have to understand the value of adjudication when we approach that conversation, I think. So that's adjudication. It's the thing that we use to maintain rule of law. Mediation, on the other hand, is not designed to maintain rule of law. It's so because mediated outcomes can be perfectly legitimate, even if they're totally inconsistent with the relevant law. So, although both processes are in the business of dispute resolution, they're very different processes, right? They have very different core values and goals. But I don't want you guys to understand this as like my critique of mediation. This is just a non-normative description of what mediation is, all right? Because that unique quality of not being bound by the laws can also be a huge advantage for mediation. So let me give you an example. So let's say that we have, I used to be really into like medical malpractice in law, not medical malpractice. I used to be really into the law of medical malpractice. So let me use that as an example. So let's say you have a doctor that misdiagnoses a patient, right? So now the patient can't, sometimes what happens in that context is the patient can't prove that the doctor's negligence actually caused their bad outcome because they were already sick and maybe that bad outcome was going to happen anyways. So sometimes it's hard for the patients to prove that causal link between the negligence of the doctor and the adverse outcome. So under the tort law framework that we have over here, which I think probably you guys have over there as well, the patient, if they can't prove that causal link, then they're out of luck when it comes to the adjudicative system, right? If you can't prove that someone else's negligence caused your injury, then you don't have a right to compensation, right? And so if that case was adjudicated, then the right outcome, the one that would protect rule of law, would be that there's no compensation awarded to the plaintiff. So that would be the right outcome in the adjudicative context. But imagine if that same dispute went to a mediation context where we're not bound by the laws necessarily, right? So here you can have a situation where the doctor says, well, I did kind of misdiagnose you and I understand that affected your life. I really want to actually compensate you in some way. Maybe we can figure something out, right? That is very possible in a mediation context. And, arguably that's a way better outcome than the adjudicative process could offer, right? So my point is not that adjudication guarantees the best possible outcomes. I don't think it does. But the argument is that the adjudicative system is the only system that's designed to protect rule of law. And because that's the case, if someone feels like their legal rights have been compromised and they want the existing laws, and only the existing laws, to govern the resolution of their dispute, then they have to have access to the adjudicative system because no other system is going to allow them to say, I only want the laws to govern, period. That's what I want to govern. So, that being the case, in my view, forcing somebody to try informal mediation or informal dispute resolution, or forcing somebody to ask for permission to access the adjudicative system directly, which can cost money and time, that is, in my understanding, a denial of dignity that cannot or should not generally be accepted within a legitimate civil litigation system. I'm going to give you another example that might make that point more clear. So I gave you the doctor example where mediation came up with a nice outcome compared to the adjudicative system, maybe, right? But let's take another example. So imagine that there is, so Teams allows like other people to take control of the presentation. So I think someone's accidentally like moving around the slides. So sorry, let me just get them back where they should be here. Okay. So here's the example that I want you to contemplate. So take a situation where there has been a sexual assault, but it's being tried in the civil context. So we're not in the criminal context, okay? So we're having a person who says, I've been sexually assaulted. They are a plaintiff in the case, and they are suing the defendant, who is the person that they say committed the assault. So in that circumstance, to me, it doesn't seem reasonable it seems reasonable for the plaintiff who, suffered this sexual assault to say, I want to pursue a legal action. I do not want to have a dialogical, cooperative encounter with the defendant. Now, somebody in that situation might want that, right? Somebody might say, I want to talk to this person and get at why they did what they did. But another person may say, I do not want to be in the same room as that person. I don't want to talk to them. I don't want to have anything to do with them. I want the court of law to decide this case, and I want the court of law to apply the laws to that person. And to me, mandating that person has to try mediation or has to try informal dispute resolution is a denial of that person's autonomy and their right to have the relevant legal frameworks simply govern in an authoritative way. So that's where I end up on the rule of law issue. So, I think taking together that problem of the denial of access to the adjudicative system and the affront to human dignity that can result from that, but also recognizing that mediation can be a great process and can lead to great outcomes, that leads me to the conclusion that, again, there's excellent reason for making good mediation available. There's good reason to ask governments to put money into making good mediation available to willing parties as part of the court system. But there is also good reason to make sure that legislators don't mandate that people have to try mediation in order to access the adjudicative system. So this is where I end up on the rule of law thing. Okay, so now if you have counter arguments brewing in your brain, make a note of them so that we can try to hash them out at the end. But that's all I'm going to say on the rule of law thing for now, so we can move on to the other angles of potential problem associated with mandatory mediation. So let me talk about the second angle, which is a bit more, I think, on the practical side. That is what I just talked about was more like a conceptual piece that has practical ramifications, but this is more squarely in the practical side. So the focus in court-connected mediation is, as I said, settlement. That is, like, you hear that in the narratives all the time. It's like, you just want cases to settle, because that's what makes mediation efficient, right? And so what I want to discuss, I want to discuss why over-prioritization of efficiency and settlement is a problem, especially for the question of whether mandating mediation is good. So again, the anchor for me is this concept of protecting human dignity. So I was going to go back to that and say, like, are we protecting human dignity? And good versions of mediation, as I think you all know and would agree with, good versions of mediation can protect human dignity really well. Because good versions of mediation prioritize the value of self-determination, autonomous control over an outcome, ability to participate and express not only your legal views, but also your emotional and other needs and wants. All of that is very much in line with protecting human dignity, I think. But the problem arises because that type of true self-determination might not actually be manifest in court-connected mediations, because court-connected mediations right now are largely rooted most firmly in the value of efficiency, not self-determination. So the driving force isn't, how do we come up with a process that really empowers people to make genuine, self-determined, fair decisions? The driving force is settlement. And so when that's the driving force, mediation doesn't always, but it can become a way to actually pressure a party to settle. Because, like, a successful mediation is seen as a settled dispute, right? So now that pressure can arise in a couple of different ways. One is where there is a power imbalance between the parties. So like, see these two guys, and oftentimes the guy up here is like a marginalized person, but there's often power imbalances. Someone has a ton more money, they can go to the adjudicative system if they want to. So, you know, there's 100 reasons why there can be power imbalances between people, and there almost always are. Imagine a situation where you have an employer versus an employee. You have a power imbalance. Imagine a situation where you have like a big company contracting with an individual contractor. Again, you have a huge power imbalance, right? So coercion can happen in a mediation context because of imbalances between the parties. And then it can also happen because implicitly or explicitly, the mediators themselves exert bias on one party or the other party. And so here in Canada, and I'd love to hear if something similar has happened in India, but there's empirical work. In fact, sorry, there isn't much empirical work in Canada, but there is some in the US, which we kind of tend to look at and say, well, it's probably reflected here as well. So there's some empirical work that shows that both of these types of compulsion or pressure can happen in mediation contexts. So there's this woman, Nancy Welsh, and there's this person, James Coben. These are kind of famous people in mediation discourses around here. And they have described how court-connected mediation can involve mediator tactics that pressure parties to settle, and tactics between parties that, again, pressure the weaker party to settle. And the concern is that all of this happens in a very informal, confidential setting where the primary purpose is to get a settlement out of these two people. So there's no public scrutiny for what's going on behind those closed doors. And in the end, the two people kind of come to a resolution, but there's no way of knowing that both of those people actually came to an equally autonomous resolution. All we know is that they got a resolution. So these kinds of pressuring tactics can occur in any mediation, no matter who the two parties are. But this also just kind of brings me into that last third lens, which is the social justice lens, because the critical race and feminist theorists and scholars have warned us, and they have been warning us for like 3 decades, that these dangers, like the dangers between these two people here, disproportionately affect people who are already marginalized in a society. So, you know, who those people are will vary country to country, but there's always marginalized people in every country, right? So there's several studies that indicate that people who are already marginalized may be disproportionately compromising or accepting of worse outcomes in informal contexts, even compared to what they may have secured in court, even considering the expenses related to taking a case through court. So for instance, women in particular, people who are less wealthy, minorities, studies seem to show that they are way more likely to accept lesser outcomes in informal dispute resolution contexts. And this can happen because of both types of pressure. So it can happen because mediators bias. So for example, there's a person named Richard Delgado who's extremely famous in raising the argument from the critical race perspective around this, but he's done work showing that mediators function kind of like decision makers, and their prejudicial biases can impact the process. So here, take for instance, you might wonder, like, how does it impact the process, right? So if you're a mediator and you have like an implicit bias that maybe you might not even be aware of, you can do things like give the person from a dominant group more time to speak. You can give them more opportunity to ask questions. You can give them more, confirmation. Like you can say, oh yeah, that makes sense from time to time. And when the mediator does that, the marginalized party or the weaker party buys it, right? Like they buy into that bias. And they say, oh, okay, well, this mediator who's supposed to be neutral is also kind of agreeing with this other person. So maybe I'm wrong. Like maybe I should accept less. Right? So this is a danger. And the other thing is that for minorities in societies, they tend to do less well in society generally. So they bring that whole self-narrative into the mediation. And so they say, well, I tend to do, they're not expressly saying that, but in their mind, they're like, I tend to do less less well in the real world, so I also expect less from anyone else, right? And so they end up worse off. You know, like why do you suppose that there's a pay gap? I mean, partly it's because women and minorities don't value themselves as highly as men, and here in Canada we often say as white men, right? So you know they don't value themselves as much, so they tend to ask for less, and that results in that, at least in part, results in the pay gap that we experience, right? So all of this stuff kind of taken together gives rise to me to a lot of skepticism around mandating mediation, saying that you have to try mediation before you get to access the court, and saying, well, hey, but mediation is efficient. Is just, you know, in light of all of this critique, it does not seem like enough of a response at all. And yet, at the same time, I still do think that mediation can be very valuable because of its many, many values that go far beyond efficiency, like flexibility, like its non-adversarial nature, like its cooperative problem solving that can improve relationships. It can foster much better understanding between parties. It has room for expression of, you know, other human experiences like emotion, which the adjudicative process doesn't always allow for. It can sometimes create or enable better outcomes that are more suitable to the two parties than the adjudicative win-loss type of outcome. And, you know, importantly, it can allow for more autonomy and self-determination, because through mediation, you're not told what your outcome is going to be. You come to that outcome yourself. So given that we have all these benefits of mediation, and then on the other hand, there's like all these risks associated, which, you know, may manifest from time to time, and it's been shown that they do manifest from time to time, where does that leave us? Like, so what do we do now with this problem, right? And I think, you know, basically for me, the issue is I do think that the best civil justice system in a country would include... Someone muted me. Okay, it would include robust adjudication, but it would also include mediation. Like, I think the best civil justice process is going to have both. But the question is, how should both of those two systems actually coexist with each other? What's the most legitimate way for them to coexist, right? That's the question that we, after all that, come back to. So I think the first thing is that we've got to move away from the dominant narratives of around adjudication and mediation. So we've got to start, I think, with the recognition that at its best, adjudication's purpose is to uphold the rule of law, and access to that system, I don't think, should be compromised. But that doesn't mean that adjudication is the only way or the best way to approach conflict. In fact, I wish we could live in a world where everyone wanted to mediate their outcomes, right? But that's not for the court system to demand. That's for individuals to decide. That's how I see it. So adjudication has its role. It's also imperfect, and there's also other ways to approach dispute resolution. So I think we also have to recognize simultaneously that mediation at its best can provide a more holistic approach to conflict. It allows for people to come together, to work through the problem, to express themselves, you know, all of that good stuff that comes with mediation. So that means that we have to recognize adjudication for what it is. We also have to recognize that mediation is not just primarily a way of efficiently getting rid of disputes. That really minimizes the value that mediation actually has. And that orientation towards efficiency causes us to mask the dangers that can come with mediation. And that is especially a disservice to groups that are already marginalized. So how do we, you know, it's one thing to say, like, this is what we have to start thinking, and it's another thing to say, well, how do we actually give effect to that conceptual shift? So, you know, I think everyone involved in our mediation programs, from the designers of the programs, so law reform, so some of you may be interested in pursuing law reform after your degree, right? Everyone from the designers of the system, law reformists, to the lawyers who are part of the system who will help clients through either adjudication or mediation, to the judges And to the mediators who will actually mediate the dispute, everyone needs to recognize this conceptual shift, I think. And so practically, how do we do that? Well, I think we've got to introduce this into the law school. So we need lawyers emerging from law school very aware that the legal aspects of the dispute are important, and the adversarial method of resolving those disputes and legal tensions is an important part of rule of law, and that is what they specialize in. So that specialization is fundamental to maintaining a fair and good society. But that conflict also has other aspects that can be relevant, and at times a non-adversarial approach is the right and the best approach. So they should be equipped to advise clients and help clients through both processes. So that's one thing. And then I also think we need to provide public education, so which informs people that when they come into contact with the legal system, they need to know that there are two potential processes. One is the adjudicative process, but there is also a mediation process, and that shouldn't be presented as just a faster process to get rid of the dispute. I mean, that is a benefit, but it should also be presented as a different, unique approach to conflict resolution that they can choose if they want to pursue that. So educational information for law students and the whole legal community is one thing, but also for the public, because I think that the public is generally sees the legal system as scary and adversarial. And so I think it would be helpful if we can say there is another process that is available if you want it. And then, again, on the theme of education, I think we have to have mediators that understand that mediation is not just to pursue and push for a settlement, and mediators that are able to appreciate or come to an understanding of their own implicit biases. That training needs to be part of mediation programs. And then, at a meta level, I think we need to continually conduct empirical reviews of mediation programs to see what people are actually experiencing in these programs. So, are they experiencing them as participatory dialogues where they get to come to their own conclusions, or are they experiencing coercion either from other parties or from the mediators themselves? How are they actually experiencing it? Because once we get that information, then we can say, okay, well, how should we tweak or change the mediation system to accommodate the dangers that might be manifesting in it. So, none of those are solutions that will can be implemented overnight. Culture shift solutions, I think, are very slow, but I think that is the way forward for achieving a kind of like a civil justice system that recognizes the value of both adjudication and mediation. It doesn't minimize adjudication to inefficiency and doesn't minimize mediation to just efficiency, because there's much more to both processes. So I think if we approach the question from that starting point, then we can get a more robust, fulsome adjudicative process. So I think I will leave it at that, and I'm happy to engage with you all further.
It is my request to all the participants that if they have any questions, they can just ask their questions to ma'am.
I think the chat box as like not able to unmute themselves.
Yes, yes, ma'am. You all can also write your questions in chat box as well. If you have any question, any doubt, any queries.
I think Brijane has question. Yeah, Brijane, you can unmute yourself and you can ask.
Yes, ma'am. Thank you. Hello, ma'am. Good evening. My name is Brijain. So my question to you is, like, there is very much criticism against mandatory mediation from lawyers, like, and disagreement might lead to litigation.
I think someone has muted him. Brijane, can you speak again? So sorry, I think someone has muted you.
Yes, ma'am. So my question is, like, there is very much criticism against mandatory mediation from lawyers, and it might be due to the apprehension of reduction of inflow of cases to them.
Yeah.
So, how should a lawyer look at the concept of mandatory mediation and how he or she can make out the most of it?
That's a great point, Brijin. I think you're right. So when the ADR movement, it arose here in the 1970s. And at that time, lawyers were like, no way, we don't want mediation. We don't like you. Like, get out of our turf, right? And part of that was legitimate based on, I think, some of the stuff that I talked about, right? But part of that was what you're saying, which is, we don't want to lose our cases to this. This I see as a problem of lawyers and lawyer ethics, because what should matter to us as a society, and I practice as a lawyer too, so I'm not just bashing them for no reason, right? I think as a society, what we need to care about is what is the best for our society as a whole, right? And I think the availability of mediation is super important for our society. So I don't think it would be right for us to respond to lawyers and say, well, we get that you want all the cases and all the money, so we'll just not have mandatory mediation. So that to me is not a valid reason to not have mandatory mediation. But the other reasons, which is that mandating people to go through mediation is a compromise to rule of law, and those other reasons, those are the ones that I think are valid. So how should a lawyer deal with mediation? I think that the right approach is for them to take a case, speak to their clients, and look through the case, see if are there potential of power imbalances, is there a potential of exploitation in a mediation context. If that's the case, then maybe the adjudicative process is the best process to pursue. But on the other hand, if it seems like there are human concerns, that the relationship between the two parties is actually very important, then the lawyer should pursue mediation. Now, I think lawyers still have a role in mediation. Like, it's helpful. I think, I'm not 100% on this, but I think it's still helpful for lawyers to attend mediations with their clients and help them through. So I think what your question comes down to really is lawyer ethics, right? It's like, am I doing the right thing for my client? Does that make sense,
Yes,
Brijin?
Yes, ma'am, sure.
A really good observation, though.
Thank you, ma'am.
Mm-hmm.
If anybody else is interested in asking any questions, they are free to ask.
You can feel free to say, I disagree. I think we should have mandatory mediation. You would be in really good company if you said that. A lot of people think that.
I think the way you have expressed the entire, starting from the principles of rule of law and what are the practical and social justice problem, what is prevailing, and how this mediation and the challenges which has emerged, and what is the need of that. So you have actually covered the, and the most important, the way towards achieving the holistic civil justice system. So I think that was a wonderful, covering all the aspect and really brainstorming session that to actually understand the foundation and the principles and the practicality that how we can actually conceptually shift the recognition of the education and mediation can how can go towards holistic approach. So I think that has a really wonderful explanation, and we are really grateful on behalf of our both the organization to have you especially to deliver the expert session on this topic. And yes, I think uh, Mr. Sandeep, you like to ask?
Yes, madam.
Yeah, please, please.
Yeah, hello, everyone. Myself, Dr. Sandeep Pandya. I would like to ask that which type of matters in mediation are more successful as
Mhm.
far as the statistical data and analysis is concerned?
So that's a lovely question, and first of all, thank you, Ishna, for your summary. I think you you gave a really nice summary of what I attempted to do, and so Sandeepji, your question is interesting because I want to ask you before I answer. What do you mean by success? So I think your question is what types of mediation are successful empirically, but what does success mean?
People, they are satisfied with the judgments, whatever orders they are getting from mediation
Okay,
centers. That
perfect.
I
So
mean to
you
ask.
Sorry. So okay, perfect. So your definition of success is on the basis of participant satisfaction, which I
Yes.
agree with. I think that's a right measure of success. And I was asking you because sometimes people will say, well, settlement rates, and that's not necessarily the same thing, right? Like sometimes settlement rates are high, but participant satisfaction is not high. So they're not always coinciding. So which ones? So I can tell you that the ones that tend to go to mediation are often, this is just limited to my own jurisdiction, but injuries, like when a person has been injured and they have sued a defendant, those often seem to go to mediation and they seem relatively successful on your metric of success. And I think part of the reason that people are happy with those outcomes is because in large part the legal outcome is pretty predictable, and the legal system, like how much money it would cost to go through the legal system on that same case, is also predictable. So I think because people can compare, okay, where am I ending up here versus where would I end up if I pursued this through the legal system, they can see the gap, and that gives rise to a feeling of a successful outcome. So I think those are successful. The other place that it has had quite tremendous success actually is in the family context. And I think the reason for the success in the family context is different from the reason for the in the injury context, because see, in injuries oftentimes there's no relationship between the parties, right? It's like you get injured by someone you don't know, and then the insurance company for that other person is on the other side taking care of the legal claim, right? So it's not really a relationship thing, but in the family context, it's all a relationship, right? And so I think people come out with a more satisfied sense of what happened through the process of coming to their settlement through a collaborative approach compared to an adversarial approach, because the adversarial approach tends to drive parties apart. And when you have a husband and a wife whose relationship has already broken down, but they have so much shared emotion, like around their children and even around their properties and stuff, the adversarial process can just exacerbate everything. So those are the two contexts that, in my view, there has been some demonstrable success: injuries and in the family context. Everyone hears about how messy divorces can be, but in collaborative family practice, it seems like parties end up in a better position at the end, emotionally at least. I hope that answers.
Thank you very much.
Yeah.
Thank you very much.
So this is the last call for questions. If you have any questions, you may ask. Otherwise, ma'am, I would like to proceed with the okay. So I suppose there are no more questions. So thank you so much, ma'am. Thank you so much for such an informative and interactive session. Now I would like to request Ms. Komal Arora madam to present the vote of thanks. Over to you, Komal ma'am.
Good evening to all of you. It is a great privilege and honor for me to propose a vote of thanks on behalf of Anand Law College and Anand College of Legal Studies, managed by Sri Ramakrishna Seva Mandal. I would like to express my deepest appreciation and profound gratitude towards our honorable guest speaker, Dr. Naya Acharya ma'am, to take out time from her busy schedule to grace this event. Thank you so much, ma'am, for sharing your views on the mandatory mediation. It is mandatory mediation and its legitimacy in civil justice. Ma'am, you have rightly explained that adjective system protect the rule of law. Ma'am, thank you so much, ma'am, for such a informative session. Thank you so much, ma'am, for inspiring and encouraging us with your kind words. We are deeply honored and blessed to have you here, ma'am. Once again, thank you so much, ma'am, for accepting our invitation. Now, I would like to thank Dr. Amit Kumar Parmar, sir, Principal of Anand Law College, and Dr. Rekha Kumari R. Singh, ma'am, in charge in Faculty of Law, Sardar Patel University. Without your bona fide and uncounted efforts, nothing would have been possible, ma'am. This webinar would not have been carried out in soothing manner. Thank you so much, Amit Kumar Parmar, sir, and Dr. Rekha Kumari Singh, ma'am. I would like to express my heartfelt gratitude to all the attendees for this active participation in this webinar. I would like to appreciate the technician for the broadcasting this event on the social media platform, as no program can be successful without a single person. So I extend my big thanks to our ALC and ACLS team of teaching and non-teaching staff for their kind support. Thank you very much for making this event successful with your contribution and support. Thank you so much, everyone.
Thank you, ma'am. Thank you so much. Now it is my humble request to all the dignitaries you may with the session. Once again, Neha ma'am, thank you so much for coming for the session, and it is a great privilege for all of us that you have invited our invitation and you came, and thank you once again.
Yeah, ma'am, we are looking forward, like, once you are in India, so we like to see you in our organization.
I would love to visit. Yeah, thank you. This was so fun and well done. I think you guys had like more than 70 people come in to this. So it was really well organized and just well done for having this much interest in ADR. I'm so happy to see that.
Thank you, ma'am. Thank you.
Yeah, I will visit you guys for sure. I'll try next time.
Absolutely, ma'am. Absolutely. We thoroughly enjoyed, and lot of like brainstorming, like thought-provoking questions where we need to understand where is the lacuna, where is the challenges, and what we can actually do for the society.
Yeah, and I think that mediation and ADR generally has a big role to play in effecting a just society. So I'm so glad that you guys have so many brains thinking about this stuff. I hope we do keep in touch.
Yes, ma'am. Yes.
So, shall I log off or yeah?
Yes,
okay.
Yes, ma'am. You can log off. Yeah. Thank you, ma'am.
Okay. Well, thank you again. That was very nice. Very fun.
Thank you.
Thank you, ma'am.
Thank you so much, ma'am.
Thank you so much.
Thank you, everyone. Thank you so much for joining. Thank you so much.
Thank you,
Thank you, ma'am.
Okay, thank you, madam. Thank you, madam.
Swara, thank you so much. Komal, thank you.
Thank you, ma'am.
Thank you, Akash bhai. Thank you so much.
Thank you, ma'am.
Thank you, ma'am. Thank you so much.
Thank you, ma'am.
It is my humble request to all the participants to kindly wait. We are sharing the feedback link for the event so that you all can fill the feedback link. Okay? So please don't leave the session uh, until we share the feedback link. Okay?